Good evening. Welcome back to our Indian polity class. We continue with the sources of the Indian Constitution. I was supposed to take the class in the morning today, but all of a sudden I was asked to go somewhere. I was out of station, in fact. That's the reason why today the class is being conducted at 4 o'clock in the evening. But from tomorrow again, as usual, we'll shift back to our morning time. That is 5 o'clock in the morning. So we have seen the introduction regarding sources of the Indian Constitution, and we have also seen what we have borrowed from Government of India Act of 1935. After that, we have seen what we have borrowed from American Constitution. Now the third one we'll see from UK, what did we borrow? As I told you in the previous class, we are coming across with lots of terminology, and understanding this technology is important. Of course, already I started receiving some of the mails from you people that you are in a position to follow the news, that you are in a position to read the newspaper without any difficulty as far as the political issues are concerned. Since you have the strong fundamentals with you today, you will be in a position to understand this. Hopefully, you will continue attending the classes very regularly. Within a very short period of time, everything will become very, very clear to you. You will be in a position to understand almost every aspect what is happening in our political system. If the Supreme Court gives any judgment, or if the Parliament takes a decision, or if the Government of India or Government of a state takes any decision, what exactly is the logic behind this? What is the rationality behind this? Everything you will be coming to know within a very short period of time. So kindly continue with your preparation. So let me straight away open the document today. We'll continue the session. Sources of the Indian Constitution. Here is the document. Now we'll try to understand what did we borrow from the British Constitution. For a quite long period of time, India was ruled by the British. We have understood these points. But the number one, we have a concept called rule of law. When I am talking about rule of law, every person in the country is equal before the law. That is a basic idea regarding the rule of law. Meaning, there is no person who is above the law. Article 14 of the Indian Constitution has mentioned about equality before law. The idea behind that article is the same thing, rule of law, meaning everybody is equal before the law. That is the reason, starting from a person at the lowest level, even to the person at the highest level in the hierarchy, will be treated equally before the law. But the Constitution has given certain relaxations to two offices in India. One is the Rashtrapati Bhavan, second one is the Raj Bhavan. Rashtrapati Bhavan is a place where the President of India lives. Raj Bhavan is the official residence of the governor of a state. Only these two offices, kindly remember, they have been given exemption of this rule of law. These two offices are considered to be above the law. That's the reason when it comes to criminal cases and civil cases, with respect to the criminal cases, either the President of India or the governor of a state cannot be arrested under any circumstances. This is the idea with respect to the so-called the criminal cases. And when it comes to the civil cases, the president or the governor will be asked to appear before the court only with a prior notice of 2 months. This is the restriction that has been given by the Constitution of India. This restriction has been given, rather the relaxation has been given to these two offices because of the dignity of these offices. One office is the highest office in the country, and the second office, that is Raj Bhavan, is the highest office at the state level. By looking at the dignity of the office, the President of India and the Governor of State have been given the relaxation, and they will be treated above the law, and they cannot be arrested just like any other person here. But when it comes to remaining all people except these two offices, they should be treated equally. Everybody is equal before the law. That is a basic idea. Am I clear? And this concept of rule of law, we have borrowed it from United Kingdom Constitution. And this is playing a very, very important role. When we start reading the Constitution of India, when we come to part 3, where we have fundamental rights, during that place, there is one article called article number 14. At that place, I will be explaining you in a detailed manner regarding the equality before law and equal protection of the laws. Okay, now, but for today, kindly remember, the concept of rule of law was borrowed from United Kingdom Constitution. Next, look at the document once. Look at this point, next point. We have a concept called parliamentary form of government. Now, let me tell you what is the meaning of this. If you look at the whole world, rather, there are so many countries which are present. In every country, there is a concept called government. And that government is either parliamentary form of government or presidential form of government. What do you mean by this? For example, if you look at India or England, these are considered to be the parliamentary form of governments. Similarly, if you look at some countries like United States of America or France, they are considered to be presidential form of governments. So there is a difference. But kindly remember, irrespective of the type of the government that is present in the country, they have to work for the welfare of the people. But how you choose your government in your own country is nothing but the type of the government that is present in the country. Deliberately, in India, we have adopted the concept of parliamentary form of government. Why? At the time of preparation of the Constitution, there was a discussion. There was a discussion in the Constituent Assembly that why can't we try for the presidential form of government? Some members have raised this question, but the majority of the members in the Constituent Assembly, they have decided that let us go for the parliamentary form of government because India has already got the experience with the parliamentary form of government because India was ruled by British, and that British itself has got the parliamentary form of government. So instead of trying for a new one, let us go ahead with the existing type of government in the country. Hence, majority of the members have proposed for parliamentary form of government, and India has adopted the parliamentary form of government with an option open, saying that at any time, if you want to shift to other type of government, you may shift. So that can be decided by the parliament later. But we have adopted parliamentary form of government, and even today also we are continuing with the parliamentary form of government. That is number one. Number two, what is the difference between, before that, let me tell you one point. Sometimes in some countries, you will also come across with the military form of government. It is the rule by the army of that particular country. And whenever army, through a coup, if they occupy the nation, if they occupy the government, if they form the government, that government is considered to be illegitimate government, and remaining other countries in the world, they don't recognize that government. That is the reason why I am not including military form of government here. But otherwise, basically, whatever the country you look at, every country will have either parliamentary form of government or presidential form of government. Now, let me tell you a few points regarding the parliamentary form of government. Kindly remember this one. Very frequently, we come across this word parliamentary form of government or parliamentary form of democracy in India. Maybe in the political circle or maybe in the judicial circle. This is a very, very common word. Let us try to understand what exactly is the meaning of this. In parliamentary form of government, though we have two important persons at the highest level, that is the President of India and the Prime Minister of India. Or if you go to England, there is something called Crown and the Prime Minister of India. Whenever two important heads are there, the real powers are vested with the Prime Minister. So through this parliamentary form of government, the real powers are vested with the Prime Minister of India and the nominal powers are vested with the President. This is one feature of the parliamentary form of government. The other one, rather the most important one, is that in any parliamentary form of government, the Council of Ministers are collectively responsible to the lower house of the Parliament. I am repeating, the Council of Ministers is collectively responsible to the lower house of the Parliament. Look at India, the lower house of the Parliament is nothing but the Lok Sabha. But what do you mean by this collective responsibility? I told you some of the points in the previous classes. If you look at Indian Lok Sabha, the maximum strength is 552, but present strength is 545. And out of this 545, there may be two Anglo-Indian members who are nominated by the President of India. But otherwise, remaining 543 members, they are elected by the people. The people are coming out and they are exercising their franchise, and we are electing our representatives, and those representatives are going and sitting in the Lok Sabha. And out of this 543, any party which gets a simple majority will claim to form the government. We know what is the meaning of the simple majority. In 543, any party which has equal to or greater than 272, they can claim to form the government. And the president will invite that particular party to form the government. If you have the majority in the parliament, that is in the Lok Sabha, the party will be permitted to form the government, and that party will continue to be there in the power or in the government as long as they enjoy the majority in the Lok Sabha, that is the lower house. So in parliamentary form of government, this is one fundamental principle. The Council of Ministers is collectively responsible to the lower house of the Parliament, means they are responsible collectively to the Lok Sabha in India. Responsibility is nothing but, kindly remember, have the majority, form the government. Whenever you lose the majority, then you have to step down and the Prime Minister must submit the resignation letter. That is the meaning of the collective responsibility. Meaning, there is no fixed tenure for the government in parliamentary form of governments. As long as you enjoy the majority, you continue in the power. Nobody will object for that. But whenever you lose the majority, you have to step down. That is number one. Number two, on the other side, if I go to the presidential form of government, the Council of Ministers is not responsible to the lower house of the Parliament. The ministers are responsible to the President, because in those countries, the President is the real executive. Parliamentary form, Prime Minister is the real executive. Presidential form, the President is the real executive. In parliamentary form, the Council of Ministers is collectively responsible to the lower house of the parliament. Whereas in the presidential form of government, the Council of Ministers is collectively responsible to the president. And as long as the president likes them, they continue in the office. Otherwise, they will be removed from the office. That is the one point. Again, I'm going to the next point. In parliamentary form of government, ministers must be the members of the parliament. Minister must be a member of either Lok Sabha or Rajya Sabha. Otherwise, within a period of 6 months, he must become a member of either of the houses. This is one fundamental principle in the parliamentary form of government. Meaning, ministers should be the members. Otherwise, within the specified period of the time, as mentioned in the Constitution, a minister has to become a member. Recently, you might have seen Goa Chief Minister Manohar Parrikar. He has been appointed as the Defense Minister of India. At the time, he was neither a member of the Lok Sabha nor a member of the Rajya Sabha. But after being appointed as a minister, immediately after that, he got elected to the Rajya Sabha from Uttar Pradesh. Hence, today, Manohar Parrikar is a member of the Rajya Sabha. That's the reason why he can continue as a minister for a long period of time. This is the latest example I have given you. But whereas in the presidential form of government, ministers are not the members of the parliament. They are coming from outside and they are answerable to the president directly. These are the differences between the presidential form and the parliamentary form. But when it comes to India, we have adopted the concept of parliamentary form of government because India has the experience of the parliamentary form of government. Am I clear? Now, we have seen 2 points today. One is the rule of law. Second one is the parliamentary form of government. Let's try to see the next one. Next point, we'll see single citizenship. Yes, what is the meaning of this? In UK, we have single citizenship. In India, again, we have the single citizenship. What is the meaning of this? I was telling you some time back, India is a federation. And we know what is the meaning of the federation. If India is a true federation, every person who is living in India will have the two citizenships. One is the federal citizenship, second one is the state citizenship. But India has deliberately adopted the concept of single citizenship. We did not opt for the dual citizenship. Otherwise, India is a federation. Though we are governed by two different governments, one from the central level, second from at the state level, the citizens are enjoying the status of the single citizenship. Hence, we are all the citizens of India. We are not the citizens of any particular state. Kindly remember, very, very important. And the basic idea of adopting the concept of single citizenship is that if you go back to the year 1947, India was integrated under very difficult circumstances. There were so many differences, there were so many disturbances. And under those circumstances, if you permit for going for the dual citizenship, in future, there may be some unexpected problems that may occur. Hence, the constitutional framers, they have deliberately adopted the concept of single citizenship. And the basic idea for adopting the single citizenship is to promote the concept of the fraternity. When I am using the word fraternity, it is the promotion of brotherhood among the citizens. Otherwise, the people may be divided on the name of the states. But today, it is not Nobody has any citizenship with respect to any state, but every person who is living in India is enjoying the citizenship of India. We are all the citizens of India. If you remember those points, India is my country, all Indians are my brothers and sisters. Very, very important one. So we talk about the country where we are living, and we don't talk about the state, and we don't have any separate citizenship with respect to any state. But there is only one state with an exception, that is Jammu and Kashmir. So Jammu and Kashmir is the only state where the dual citizenship is permitted. Number one, they are all the citizens of India. Number two, they also hold the separate citizenship for Jammu and Kashmir. Hence, they are the citizens of India. They are also the citizens of Jammu and Kashmir. This is applicable exclusively and only for Jammu and Kashmir and not for the remaining areas, remaining states. This was deliberately adopted because Jammu and Kashmir became an integral part of India under special circumstances. That's the reason why even today also Jammu and Kashmir is enjoying the special status under the Constitution. So during that time, one of the agreements was that they should be provided with state citizenship also. Hence, they were permitted and they are enjoying the dual citizenship. With an exception of Jammu and Kashmir people, all the people who are living in the country, in all the remaining 28 states and 7 union territories, everybody will enjoy one single citizenship, that is called single citizenship. This is what we have borrowed from UK Constitution. Kindly remember this. And the basic idea is for promotion of brotherhood among the citizens of the nation. Am I clear? So this is the meaning of citizenship. And of course, citizenship is a bigger topic. When we come to the part 2 of Indian Constitution, we'll try to have a discussion. Next one. Next one is the cabinet system. What do you mean by this cabinet system? Sometime back when I was talking to you about the Council of Ministers, so during that time I made it very, very clear. Let me write it for your sake once again. So I have the Prime Minister, I have somebody called Cabinet Ministers, and after this I have Ministers of State. So this is what we have seen. And previously there is something called Deputy Ministers, and today, so I don't have any Deputy Minister. That is the reason, let me remove it from here. But otherwise today, I'm highlighting it here. We have the Prime Minister of India, we have the Cabinet Ministers, and we also have the Ministers of State. But if you go to the above point, I'm talking to you regarding the cabinet system. When I use the word cabinet system, this is a part of a Council of Ministers. Kindly pay attention once again. Highlighted portion of the document. PM, that is the Prime Minister, Cabinet Ministers, and Ministers of State. All the three levels put together is called Council of Ministers for me. But within the Council of Ministers, I have something called Cabinet. When I use the word Cabinet, I am talking to you only about the top 2 levels. That is the Prime Minister and his Cabinet colleagues put together is called the Cabinet system. But I told you already, the words Cabinet Minister is nowhere mentioned in the Constitution. For that matter, the word Cabinet was also originally not mentioned in the Constitution. But over a period of time, through the 44th Amendment of the Indian Constitution in the year 1978, we have added the word cabinet in article number 352. Okay, I'm just giving you little information here, but when I come to the topic, actually article 352, we will try to have an elaborate discussion on this. But otherwise, the word cabinet is nowhere mentioned in the Constitution. Number one. And we have seen so many times, even in the newspaper or in the TV channels, very frequently you will come across with the word cabinet. And hence, for me, the cabinet is the most important body in India, which is headed by the Prime Minister, and every important decision will be taken only in the cabinet. That is the reason why cabinet is nothing but a group of members, group of ministers, and that group is the real executive group for me. And this concept we have borrowed it from British Constitution. Okay, kindly remember, I am not talking in terms of the Council of Ministers. Cabinet is a smaller body. Cabinet is a part of Council of Ministers. But that cabinet is very important for me because every important decision in India will be taken only there. Am I clear? And we got it from the so-called British Constitution. Next. Next, we have something called legislative procedures. We have seen on day number 1 how the bills are introduced, how the bills will be discussed, how the bills will be voted, ordinary bills and money bills. Apart from this, there are so many other procedures in the legislature, that is in the parliament. When we come to the actual topic of the parliament, we'll have a detailed discussion regarding that. But most of the things what are happening in the legislature of India today, that is in the parliament, they have been taken from the UK Constitution. That is another one. And the last one, if you look at this, bicameralism. And we know what is the meaning of the bicameralism. It is nothing but these are the two houses that are present in the parliament. Of course, there are so many countries in the world where they have two houses in the respective parliaments. But whatever the bicameral legislature we have in India, that has been borrowed from UK Constitution. Hence, with respect to the ordinary bills, whatever the procedures I have explained you in the previous classes, same thing is followed in UK. In fact, whatever we are following in India today, that has been borrowed from UK Parliament. Money bills, the upper house of UK Parliament, that is called House of Lords, it has no powers with respect to the money bills. In the similar manner, when it comes to India, the upper house, that is the Rajya Sabha or the Council of States, it also does not have any powers with respect to money bills. But there may be so many other countries in the world which has equal powers with respect to all the bills. But in India, we have adopted the bicameralism concept, and that was taken from UK Parliament. Am I clear? Next. Look at this. Just to have a recap if you want. This is the British Constitution. From here we have borrowed all these concepts, please. Rule of law, parliamentary form of government, single citizenship, okay? Single citizenship, cabinet system, and I'm removing some points here. Already I explained to you. Don't worry. Now, look at this. Legislative procedure, bicameralism, all these we have borrowed it from the British Parliament. That is the British Constitution. Okay. Now, I'm going to the next point here. That is the concept of directive principles of state policy. Nomination of the members to the upper house. Election method of the president. These three concepts we have borrowed it from Irish Constitution. It is the Ireland Constitution or Irish Constitution we call it. These are the very, very important concepts. If you look at the number 1, very frequently you will come across with the concept of directive principles of state policy. Again, it is a part of our constitution. Part 4 of the Indian Constitution mentions about DPSP, or it is called a directive principles of state policy. Kindly see here, In the examination, you just follow one thing. In the preliminary examination, maybe they will give either directive principles of state policy or DPSP. You can understand, no issues. But when it comes to the main examination, in the question, if they use directive principles of state policy, 1, 2, 3, 4, 5 words are there. While writing the answer, you also use directive principles of state policy, at least in one place. And beside that, just like me, you just keep DPSP in the bracket. And after this, in that particular answer, wherever you are going to write directive principles of state policy, you may just write DPSP. But writing directive principles of state policy, at least at one place, is very, very important for the examination point of view. If you write DPSP like this, that will be considered as one word. You can save some words and that can be utilized for giving some other additional information or additional analysis in the answer. That will fetch you good marks. Okay, right. Next, sometimes in the question itself, they may be giving you something about DPSP directly. Since you know what is the DPSP, straight away you can start using the word DPSP even in the answer. There you need not mention directive principles of state policy. If you want to mention also, no issues, but mention it only one time. But from second time onwards, in the same answer, you have to mention DPSP itself. Hope you are following this one. Kindly follow this. These are some mechanisms how you can save the number of words. Now let me tell you what is the meaning of this directive principles of state policy. Let me explain certain points to you. Kindly remember all the words. I am coming back to you on the screen. Now let me tell you directive principles of state policy. Directives, nothing but these are the directions. Principles are nothing but the guidelines or the rules, procedures that are given of state. I'll come to this word state after some time. Policy is nothing but the program. Meaning the Constitution has given certain directions for the welfare of the people, and that welfare should be taken care by the people who are there in the power. And that power is nothing but the state. This is what is explained by the Constitution. And when you look at the word state, generally, in the normal sense, if I am using the word state, we are talking about a regional area. It's a region that is present in the country. Say, for example, Gujarat is a state, Assam is a state, Nagaland is a state, Gujarat is a state, Karnataka is a state, Maharashtra is a state. Like this, we are using the word state. It is a general sense. We are talking about a particular geographical area. But when it comes to the Constitution, the word state has been explained in an elaborate manner. And the word state was explained in two different articles in the Constitution. That is article number 12, which is a part of fundamental rights. It was also explained in another article called article number 36. Article 36 is a part of the directive principles of a state policy. Hence, wherever you are coming across with the word state here, kindly don't go by the word what we use at the region level. The meaning is elaborate. Now let us try to understand what is the meaning of the word state. Now, state is nothing but it's an institution or it's a group of people which is there in the power to take the decisions and implement the decisions. And in India, or at any level in India, maybe at the central level, maybe at the state level, maybe at the local level, if there is any institution which is taking a decision and implementing the decision, and with the decision, if a person who is living in India is affected, that particular institution which has taken the decision is state. That's it. Hope you are following me. Now let me explain you in an elaborate manner. For example, we have parliament in India. We know what is a parliament. They will take certain decisions. Yes or no? Yes, they will take the decisions. They will introduce the bills, they will pass the bills, and that bill will become an act. Once that act is implemented, we are going to be affected. Maybe in the positive manner or negative manner. Most of the policies are aiming at positive side only, that is meant for development. Because the parliament is taking a decision and because that is affecting the people of India, I am using the word state for the parliament. Parliament is a state for me. Similarly, if you look at the executive, that is nothing but the council of ministers. They will also take the decision and they will implement the decision. And because of that decision, we are going to be affected. Hence, the government of India is nothing but a state. Parliament is taking a decision, government is taking a decision, that is the executive. Hence, these two are nothing but the state for me. State is an institution where the decisions are taken, where the decisions are implemented, and with that implementation, if the people are affected, that institution is called state. Am I clear? Next, let's come down to the state level. Let me have some water. At the state level, we have a state legislature. We also have the state government. Just like the parliament, the state legislature will also take the decisions. Just like the central executive, the state executive will also take the decisions. When that is a state, this should also be a state. Meaning in the state legislature, you are taking a decision. State executive is taking the decision and they are implementing the decision. Because we are affected by that decision, hence state legislature is a part of the state. Executive is also a part of the state. So today for me, parliament, central government, state legislature, state government, these are all considered to be the part of the state. Apart from this today, we have the local bodies, so-called the local self-governments. Nothing but the Panchayati Raj and the municipalities. Today, under the Constitution of India, they also have every right to take a decision and implement the decision, and this decision is affecting the people. Hence, Panchayati Raj is a part of the state. Similarly, municipalities are also taking the decision and implementing the decision, and those decisions are affecting the citizens. Hence, municipality is also a part of the state. Similarly, the last one, at the end we have other statutory and non-statutory organizations. We know what is the meaning of the statutory and non-statutory. Say for example, LIC will take a decision, NHRC will take a decision, RBI will take a decision, and if with those decisions, if the people are affected, then those institutions are also the part of the state. Non-statutory organizations like NDC, Planning Commission. Of course, you must be knowing, Planning Commission is very soon, it is going to be replaced with other institution, maybe by January 26th next year. But if any institution is present which is considered to be a non-statutory, and if you take a decision and if the citizens are affected by that, then again it is called a part of the state. Hence, for me, state is nothing but Parliament of India, Government of India, legislature of a state, and state government, local bodies like Panchayati Raj and the municipalities, and other statutory and non-statutory organizations. All these are nothing but the part of the state. Hope you are following this. Kindly remember this. When I come to this article number 12, I am going to explain you again the same things I am going to repeat during that time also. Whatever I am going to say in article number 12, the same thing will also be present in article number 36. Okay, and I can avoid the same discussion in article number 36. But for time being, kindly remember this DPSP, Directive Principles of State Policy. Any institution that is there in the power should take the decisions, prepare the welfare programs, and implement the programs. And this concept we have borrowed it from Ireland Constitution. Kindly remember this. Very, very important point. In most of the times in preliminary examination, it's a question. And when it comes to the civil services main examination, very frequently it has been asked. There are so many articles under this, starting from Article 36 up to Article number 51 in the Indian Constitution. When I come to that area, I will have a detailed discussion regarding each and every article. That is again another very, 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 very important point. Okay, next. But time being, remember, the concept of DPSP was borrowed from Ireland Constitution. That is nothing but Irish Constitution. Okay, let me open the document again. I'll show it to you. Next one is the nomination of the members to the upper house. What is the meaning of this? We have seen, we know what is the meaning of the upper house in India. That is nothing but the Rajya Sabha. Otherwise, you can call it Council of States as mentioned in the Constitution. And we also understood that for that particular house, not more than 12 members are nominated by the President of India, and these persons are the persons with special knowledge or practical experience in 4 different fields that is mentioned in the Constitution: science, arts, literature, or social service. We have seen these points. And whatever the President of India is doing today, this concept of nominating the members to the upper house, this has been taken from the Ireland Constitution. That is nothing but the Irish Constitution. Is it okay? Right. Next. See here, one more point I would like to tell you. Once the class is over, the video is not going anywhere. Either you are, if you are subscribed to me through YouTube, every video is there that will be present in YouTube only. And I'm expressing my complete gratitude towards this YouTube and Gmail for such a nice platform that has been provided by them. Every video will be present in the YouTube. Kindly watch it. And once the class is over, the same video I am uploading in our site OnlineIAS.com. And you please search certain things with patience. That is important. Apart from the home, registration, subjects, and so many things, at the higher level, at the top of the screen, you can also see something called videos. Please click on that videos and you will have the complete list of the videos what I have uploaded with respect to Indian polity. For current affairs videos, that is present in current affairs site, you know. And from OnlineIAS site, OnlineIAS.com site, at any time you can shift to current affairs site. You have a symbol over there, just click onto that, you can go there. Similarly, from there also you can come here. Everything is arranged, but only thing is that look for the site. What exactly is the present in the site, so that you can shift yourself from one place to the other place. So please click on that videos, and you will see all the videos, and pick up whatever the video you want to watch and watch it very nicely. Okay, some people are getting confused. Don't get confused. Have patience. Open it. Read each and everything that is available in the home screen. Then you can understand this very easily. Is that clear? Now, let me come to the last point in this one. That is, look at this. Nomination of the members to the upper house is over. Election method of the president. And we know that there is a president of India, and the president of India is elected through indirect election. So this is what we have observed. And the president is elected through proportional representation by means of a single transferable vote. In the Constituent Assembly, there was a discussion how it will be if the president of India will also be elected directly. But some of the members have opposed for this. Imagine a situation, if the president is elected directly by the people, he is directly representing the people of the nation, then he should be given some real powers. On the other hand, the constitutional framers wanted that India should be a parliamentary form of government. In parliamentary form of government, we have understood that the president will be the de jure head, constitutional head, or nominal head. And the real powers are vested with the prime minister, who is also called the de facto head. One side you want to give the real powers to the prime minister. On the other side, you want to elect the president of India directly. Meaning, it will be leading to the contradiction and the clashes between these two offices. But the constitutional framers wanted these two offices must work with coordination and lots of cooperation. So it is not expected that there will be a contradiction. That is the reason why finally we have decided to have the election of the president in an indirect manner. Hence, the president of India is elected indirectly. He is elected by the elected members of the Lok Sabha, elected members of the Rajya Sabha, elected members of the state legislative assemblies, and he is elected by the elected members of assemblies of Delhi and Pondicherry. So these are the four categories of the people who are taking part in the election of the president and who are voting in the election of the president. The other people in the country, they are not permitted to vote in the election of the president. Kindly remember this. And when it comes to this election, that is the indirect election, we are using a concept called proportional representation. This mechanism we have borrowed it from Ireland Constitution. Am I clear? Right? Now I'm just going back to the screen. Kindly remember. But see here, when I come to the topic of the president, which is the part 5 of the Indian Constitution, I will tell you so many points regarding the president of India, including the procedure, what is followed, how you elect the president of India, and how you remove the president of India, that is impeachment. Okay, for example, here, yesterday when I was talking to you, I told this, there is a procedure for impeaching the president of India, and that impeachment procedure we have borrowed it from United States of American Constitution. Impeachment from American Constitution. But today I am talking to you regarding the election method of the president of India. From where did we borrow that one? We have borrowed it from Ireland Constitution. That's the reason, if anybody says that Indian Constitution is a copied one, that is their mistake. That is their mechanism of understanding. Hence, in the initial days itself, our members in the Constituent Assembly, especially Dr. B.R. Ambedkar, he rejected all such type of comments. Ours is not a copied one. We have borrowed it. Yes, we have borrowed it from various sources, but not as it is. We took in such a format where it will be suiting to our needs. Hence, we have modified them and we have integrated them into the Indian Constitution. This is what our people have said. Is that okay? I'm just going back to the screen for the sake of recap here. So two things we have seen. One is the Ireland Constitution. Second one is the British Constitution here. From British we have seen, we have borrowed rule of law. Remember, parliamentary form of government, single citizenship, cabinet system, legislative procedure, and bicameralism. And when it comes to Ireland Constitution, we have borrowed directive principles of state policy. I told you what is the meaning of the state. That is the most important word for me as far as the examination for civil services is concerned. That is the reason why I took enough time to explain the meaning of the state. If you have already understood, that's well and good. Otherwise, kindly watch this video once again for better understanding. Apart from this, nomination of the members to the upper house was also borrowed from Irish Constitution. And the third one is the election method of the President of India. Clear? And I told you already, this method we'll see when I come to this topic. But 1, 2, 3, these points we have borrowed it from Irish Constitution. Okay. Now, I'm coming back to the screen only to say goodbye to you. So I'll be stopping at this stage. And tomorrow morning, again, we'll meet at 5 o'clock and we'll try to complete the rest of the topic, that is the points that are left in the sources of the Indian Constitution. Okay, so this is one important area where we are coming across with various terminologies. Hence, please watch this particular video again and again to understand more. Am I clear? So thank you so much for being with me this evening, and we'll meet at 9 o'clock in the evening today for a current affairs session. And for Indian polity, we'll be meeting as per our schedule, that is tomorrow morning, 5 o'clock. So thank you so much. Thanks once again. Have a nice time. Good day.